So, what's a brief? A brief is a summary of a case. It can be as basic or as detailed as you need it to be. It all comes down to your own personal preferences. In this video, I'm going to show you my method of briefing cases. Who am I? Well, I'm a 3L attending law school in Boston, and I'm making this video because when I was a 1L, my notes were absolutely atrocious. And it's not because I didn't do the work. It was because I didn't know what law school exams were all about. I didn't know what information I actually needed, never mind how to call it all down effectively. What I didn't realize at the time was that studying for class in law school is so different than studying for exams. What I've come to learn is that briefs are mainly for class, and they're especially useful when you're on call. It's the holdings and the rules from these briefs that are what you're going to need for your exam outline. But well, more on that later. Let's get back to the brief. There are 10 important parts of a case that you should really put in your brief. The title, the procedure, the prosecution or the plaintiff's argument, the defendant's argument, the facts, the rule, the issue, the holding, the reasoning, and the dissent. The title is, well, exactly that, the title. It's the name of the case. I mean, you need to know what case you're briefing, right? In this, you should also include the court writing the opinion and the year it was handed down. The procedure is the history of how the case has moved through the court system. It provides a backdrop for why the case is in front of the court writing the opinion. The P arguments and the D arguments are essentially two sides of the same coin. It's a summary of each party's stance on the main issues in the case. The facts are what happened between the parties leading up to the case. In fact, they're what caused the case. Take note of the people involved, the dates when events occurred, and any other particular circumstance that may affect the legal analysis. While details are important, it's ridiculously easy to either get too caught up in the details or to get tired and start cutting corners. Really try to avoid doing either of these. When you're starting law school, keep in mind that identifying material facts is a learned process, and the more you practice, the better you'll get at it. The rule. A lot of briefs I've seen offered online use this section of a brief to summarize the rule of law developed by the case you're reading. However, this belongs more in the case holding, I think. Instead, what I use this section for is to list the rule of law the court uses in developing their legal analysis and coming to their holding. Not only does this help you understand the court's thought process or the reasoning, it helps frame the holding amidst the existing law at the time. The issue is the problem the court is trying to resolve, or the question that it's trying to answer. As details can play a huge part of the court's answer, the holding, a good issue will include such material facts within it. For example, in Brown v. Mississippi, suspects were brutally beaten by police officers until they confessed to murder. Crazy, right? The court was trying to decide whether or not these confessions should be used against them. So, in my brief for this case, I actually had two issues in this section. 1. Can a defendant's confession that is extracted by police violence be entered into evidence? And 2. Does a confession extracted by police violence violate the Due Process Clause of the 14th Amendment? The holding. This is the court's answer to the issue presented. A good issue will make the holding an easy yes or no answer. If the case establishes an important rule of law, it's a good idea to reword it into a clear statement and include it with the yes or no answer. The reasoning is, well, the court's legal reasoning behind their conclusion, aka the holding. This section, in conjunction with the rules section I've suggested earlier, helps give an understanding for how and why the court held the way it did. It should break down the components of what went into the conclusion. The dissent is a section that describes the arguments of any dissenting opinions in the case. These dissents are either for the case holding itself, or they agree with the case holding, but not with the analysis that goes behind it. In some areas of law, the dissent can be a surprisingly important part of the case. For example, in a lot of early antitrust cases, The dissents often foreshadow changes in the law for the very next case they hear on the issue. So, this brief is a lot more detailed than other methods, I know. A lot of other methods omit the P and the D arguments altogether, and they use the rules section as a summary of law provided by the case holding. However, I recommend this method, especially for cases you know you're going to be on call for, because it outlines all aspects of the case a professor may want to know, and it does so in a clear, coherent way, so you not only know the case inside and out before you walk into the classroom, but the information is easily accessible to you when you put on the spot. Well, I hope you found this video helpful. I'm going to be doing more videos like this one on how to survive law school, and even video study guides covering important topics for class exams and the bar. So if you have a suggestion or request, just let me know. Thanks for watching.